The $500,000 trap, how Medicaid steals your home, and how to stop it. If you own a home, you're walking into a $500,000 trap. Let's be honest, most of us think a will, a living trust, and a few beneficiary lines make us safe. They don't. Medicaid can still take the house after you pass. And reading the rules feels harder than teaching your grandkids a rotary phone. Don't worry, we've all been there. Today, I'll expose the lie that costs families up to $500,000, show you the 5-year look back in plain English, and give you 3 simple moves to lock the door legally. Stick with me. The last step is the one nobody tells you. The trap map, how Medicaid really takes the house. If you remember nothing else from this section, remember this. There are 2 doors, eligibility and recovery. You can qualify for long-term care today and still lose the house later. That's not a contradiction. It's how the system is built. Here's the why. Medicaid is the only program that actually pays for long-term care when savings run out. Federal law then requires states to seek payback from the estates of people 55 or older for nursing home care, home and community-based services, and related costs. It's called estate recovery. Eligibility gets you care. Recovery tries to get reimbursed after death. 2 doors, different timelines, same house. And for 2025, states also look at home equity for eligibility. Most states allow an exempt equity cap in the ballpark of the low $700,000s up to around $1.1 million, depending on where you live. Above that, the home can be counted. Now, where most families get blindsided is language. I have a will. Wills only control who gets what after you die. Estate recovery steps in before that distribution is final. A state claim can attach to your estate and get paid ahead of heirs. The will didn't fail. It never protected against creditors. I put my house in a living trust. A revocable living trust is still you for Medicaid. You control it, you can revoke it, you benefit from it. Because control stays with you, assets in a revocable trust are countable for eligibility and available for recovery later. That trust is great for probate efficiency, not for Medicaid protection. The thing most people miss is the difference between revocable and irrevocable. We'll get to the protective version later. So, what exactly does estate recovery target? For people 55 or older who received long-term care benefits, states must attempt recovery from the estate, typically the probate estate. Some states go further and define estate to include non-probate transfers like transfer on death deeds, payable on death accounts, and certain trusts. That's why neighbors in different states tell very different stories. The mechanics rhyme, but the definition of estate can be broader or narrower depending on where you live. When does it hit? After death. And only if there's no surviving spouse, no child under 21, and no blind or disabled child. If any of those exist, federal rules delay or prevent recovery. States must also offer hardship waivers when recovery would cause undue hardship. Think modest estates, sole income-producing property, or a farm that keeps the family afloat. The standards and thresholds vary by state, but the door is there. Now, the lien moment. During your lifetime, the state generally can't force the sale of your occupied primary residence for eligibility. But once you're permanently in a facility and no protected relatives live there, some states can place a lien. It sits quietly. You still own the home. You can even leave it in a trust or will. But when the home is sold or the estate is settled, the lien demands payment for Medicaid costs paid. Families discover it when the title company calls at closing. Others avoid a lien, but meet recovery later through the estate claim. Different roads, same fork. Let me show you the sequence most families miss. A parent qualifies for long-term care. The home remains exempt for eligibility while they intend to return or while a spouse lives there. Care is covered. Years pass. The parent dies. There's no surviving spouse and no qualifying child in the home. The estate opens. A recovery claim arrives, covering facility care, home and community-based services, plus hospital and prescription costs tied to long-term care. The executor can sell the house to pay debts, including the state's claim, before heirs see a dollar. The kids are shocked because they believed that we're set. We have a trust conversation from years ago. The state angle matters. Some states limit recovery to probate assets. Others use expanded recovery and can reach non-probate transfers. Some set small estate thresholds or carve out homes of modest value. Hardship waiver rules differ. Family income tests, business or farm exceptions, income-producing property limits. You don't have to memorize every rule, just understand the pattern and verify locally. Now, where do revocable trusts fit? They make probate smoother and faster, but they do not wall the house off from recovery. The state looks at who had control and who benefited. If that's you, the house stays exposed. The quiet trap is the kitchen table deed into a living trust years ago that everyone thought solved everything. It didn't. And if that transfer happened inside the look-back window for an irrevocable strategy attempt, it can also create a separate eligibility penalty. Wrong tool, wrong timing, double pain. Trust me on this one. Control equals exposure. Here's a quick mental model that keeps you safe. Ask 3 questions. Is this tool about eligibility or about recovery protection? Do I keep control or do I truly give it up? What does my state count as the estate for recovery? If you keep control, Medicaid counts it. If your state uses expanded recovery, non-probate tricks won't help. If your tool only avoids probate, it won't beat recovery. Once you nail that, everything else clicks. Before we move to timing, here's the payoff. Your home can be protected, but not with a will or a revocable living trust alone. You need either the right irrevocable structure, funded early, a qualifying exception, or a clean alignment of titles and beneficiary designations with state-specific rules. Next, we'll set the 5-year clock that decides winners and losers. The 5-year look-back clock, the timing that saves or sinks you. Before you touch a deed, you need the clock. The look-back is Medicaid's microscope on your last 60 months. They're asking one question: did you give away or transfer assets for less than fair market value to qualify? If yes, they don't ban you. They delay coverage with a penalty period. That's the sting. Gifts don't save the house if the timing is wrong. They delay the help you actually need. Why this matters is simple. Most families try to fix things late. A well-meaning $50,000 transfer to the kids for safekeeping. Inside the look-back isn't protection. It's a timer that blocks care payments when you need them most. If you remember nothing else here, remember this: the look-back isn't about intent, it's about math. Even kind, innocent gifts get counted. So what's the math? Each state publishes an average monthly nursing home cost figure. You take the total of all uncompensated transfers in the look-back and divide by that monthly rate. The result is the number of months Medicaid won't pay. Example, if your state's divisor is $8,000 and you gifted $50,000, $50,000 divided by $8,000 equals 6.25. Medicaid rounds per state rules, but you're looking at roughly 6 months of no coverage. Care must still be paid for. That's where families get crushed. Dates matter. The look-back window counts back from the date you file the application, not the date you start planning. Transfers older than 60 months usually fall outside the window. Transfers inside it are fair game, and the penalty doesn't start ticking on the day you made the gift. It generally starts when you're otherwise eligible and have applied. Translation: you can be broke in a facility and still waiting out a clock you created with a rushed gift. Let's anchor a safe versus danger timeline. Circle 2 dates. the date you fund a protective irrevocable trust or otherwise transfer an asset, and the planned application date if care is likely. If you can keep a full 60 months between those two dates, you're past the microscope. If you can't, you need a different path. Exceptions spend down alignment or bridge funding, so you don't land in a gap. Common myths make this worse. Small gifts are fine. Medicaid doesn't use the IRS gift tax rules. There's no free $18,000 per person exclusion in this program. 10 small gifts count like one big gift. The house doesn't count. The home can be exempt for eligibility while you live there or a spouse remains, but a transfer of the home inside the lookback is still a transfer. Exemption for eligibility is not exemption from transfer penalties or recovery later. One more twist: California uses a shorter 30-month lookback for many cases and has been changing its rules, but timing still matters and recovery still exists, so you still need a clean plan. Here's the sequence that stings. Mom gives each grandchild $10,000 at holidays for 3 years. Everyone smiles. 2 years later, she needs long-term care and applies. The agency totals those gifts, say $60,000, and divides by the state cost. A penalty appears. Coverage is delayed. The facility wants payment. The family scrambles to undo gifts or write checks. Nobody intended fraud. The clock didn't care. Now, the exceptions, the legal guardrails that let transfers pass. The Caregiver Child Exception allows a home transfer if an adult child lived in the home for at least 2 years immediately before institutionalization and provided care that kept the parent out of a facility. You'll need proof, dates, duties, medical notes tying the care to delayed placement. The sibling with equity exception works when a sibling has lived there at least 1 year and already has an ownership interest. Your lawyer can structure a proper deed. Spousal transfers are permitted, and transfers to a blind or disabled child or into certain sole benefit trusts for them are allowed. Miss the criteria or the paperwork, and the exception collapses. Once you nail the timing, tools become safer. An irrevocable trust funded more than 5 years before application can remove the home from both eligibility and recovery in many states if you truly give up control and keep the trust clean. Fund inside 5 years, and you've just created a disqualifying transfer unless an exception applies. That's why late kitchen table deeds to kids are so dangerous. You lose control and trigger a penalty with no plan to bridge it. What do you do if you're already inside the window? You shift goals. First, stop the bleeding, no more gifts. Second, map every transfer in the last 60 months with dates, amounts, and recipients. Third, explore fixes, documented repayments from recipients, promissory notes that comply with state rules, caregiver agreements that are written, reasonable, and paid prospectively, not retroactively. Fourth, build a bridge that can be private pay, a partial spend down to allowable items, or short-term products vetted by counsel. The point is to survive the penalty period without risking the house. 2 quick wins you can implement this week. 1, create a 1-page look-back ledger for your parent. 5 years of account closures, large withdrawals, and gifts with supporting statements. This prevents surprises and speeds approvals. 2, set a no-gift family rule. Birthdays, holidays, tuition. Pay only if it's in a written, market rate agreement or it's within an exception. Everything else is paused until you've met with an elder law attorney who knows your state's divisor, start date rule, and exception documentation. Timing is the first guardrail. The right tool is the second. Up next, we'll talk about why revocable living trusts don't protect the house, and what actually does when you give up control early and cleanly. Why living trusts don't protect the house, and what does. Let's clear the biggest confusion first. A revocable living trust is you with different stationery. You can change it, revoke it, pull assets out, and you benefit from everything inside. Because control stays with you, Medicaid treats those assets as yours for eligibility and for estate recovery after death. So, yes, a living trust can avoid probate and speed distribution, but it does not shield the house from recovery. If you remember nothing else, remember this: control equals exposure. Now, what would actually protect the house? An irrevocable trust designed for Medicaid planning, often called a Medicaid Asset Protection Trust. The core idea is simple and a little uncomfortable. You give up control. You move the home into the trust. You are not the trustee. You can't demand principal back. And you can't revoke the trust on a whim, because you no longer control the asset. And if you fund the trust outside the look-back window, the home can be excluded for eligibility and stand outside estate recovery in many states. Why does giving up control matter so much? Medicaid and recovery rules look at who can reach the asset. If you can revoke the trust or direct distributions to yourself, the state can argue it's available and recoverable. If you can't, and the trust is drafted cleanly with independent trustees and no backdoor powers, you've changed who owns and controls the property. That's the legal line. There's a price for that protection. Trade-offs include timing, access, and flexibility. Timing: fund the trust at least 5 years before a likely application in most states. Earlier is safer. Access: you keep the right to live in the house, but you can't pull equity out of principal for your own benefit. Flexibility: changes require careful drafting. You can usually reserve a limited power to change who inherits among a class of family, but you don't keep a revocation switch. The trust must be real. Let me make this practical. Done right, an irrevocable trust can let you stay in the home, keep the homeowner's exemption, and even keep senior tax benefits where state law allows. You continue to pay taxes, insurance, and ordinary upkeep. If the house is sold, proceeds stay in the trust and must be reinvested under the trust's rules, typically into another home or financial assets for your heirs. Money doesn't flow back to you. That's the discipline that preserves protection. And yes, we keep this at a grade 4 level, no legal gobbledygook. Taxes and insurance are common worries. For many plans, the trust is drafted to be grantor for income tax purposes, so property tax exemptions and capital gains step-up for heirs may still work when you pass. Verify this locally with counsel and a tax advisor. Insurance companies can list the trust as an insured party and you as a resident. Your agent will provide the right endorsements. The practical takeaway: day-to-day living can feel the same, but check the paperwork. Red flags to avoid: sham trusts that leave you in control as trustee, trusts that let you take principal anytime, kitchen table deeds to children without a trust, and too good to be true pitches that promise full access and full protection. If you can reach the money, Medicaid will say it's yours. If you hand the deed straight to a child, you risk their creditors, divorces, and look-back penalties. Use a real trust drafted by an elder law attorney who practices in your state. You might ask, what if we need cash for care before 5 years? That's why timing and a bridge plan matter. Start the trust early for the house, then pair it with a clean spend down for liquid assets, home safety upgrades, medical care, debt payoff, and other allowable expenses, so you don't yank equity back and break your shield. If care starts sooner than expected, talk to counsel about state-specific strategies to cover the gap without undoing the trust. One more critical nuance: your state's definition of estate. Some states recover only from probate estates. Others use expanded recovery that can reach certain non-probate transfers, and some trusts, irrevocable trusts, are typically set up to avoid probate. But you still want counsel confirming how your state treats trust property for recovery. The structure, funding date, and state rules must align. Here's a clean checklist you can act on this month. 1. Talk to an elder law attorney about a Medicaid-focused irrevocable trust, not an all-purpose living trust. 2. Confirm you'll keep lifetime occupancy, property tax treatment, and proper insurance. 3. Pick an independent trustee you trust, with a documented successor plan. 4. Fund the trust with the deed now and record it properly. 5. Keep the trust clean. No personal principal distributions, no commingling, and no late fixes that trigger look-back penalties. Control equals exposure. Early, real transfer equals protection. That's the trade most families need to make while health is good. And the 5-year clock can run quietly in the background. Once you anchor that the rest of the plan, exceptions, spend down, paperwork, supports the shield rather than fighting it. The legal exceptions that can save the house. Now that you know control equals exposure, here's the good news. There are narrow but powerful exceptions that let you transfer the home without a penalty, and in many cases, keep it out of recovery if you meet the criteria and document them cleanly. Think of these as legal on-ramps carved into the rules, not loopholes. First, the Caregiver Child Exception. If your adult child lived in your home for at least 2 full years immediately before you moved to a nursing facility, and their care delayed that institutionalization, you can transfer the house to that child without triggering a look-back penalty. The lived-in piece is literal. Driver's license, address, tax returns, and utility records help. The care that delayed piece needs medical tie-in, notes from your doctor or care team showing your child's hands-on help kept you safely at home longer. Daily duty logs, medication lists, appointment notes, and incident records make this credible. If it's real, paper it like it's real. Next, the sibling with equity exception. If your sibling owns a share of the home and lived there for at least 1 year immediately before you entered a facility, you can transfer your interest to that sibling without penalty. The equity has to exist before the transfer. Show it with a deed or recorded ownership. The residency must be continuous and provable. This one's often missed because siblings don't formalize co-ownership until it's too late. If a sibling is sharing the home and contributing, fix the title now and save receipts for taxes, repairs, and utilities that back their stake. Spousal protections are their own lane. Transfers between spouses are permitted. If you enter care, your home can remain exempt while your spouse lives there, and the Community Spouse Resource Allowance, CSRA, protects a chunk of combined assets so they aren't impoverished. For 2025, many states use a maximum CSRA around $157,920. Your state can differ. After you pass, recovery is deferred while your spouse is alive. That doesn't mean you stop planning, but it does mean you shouldn't panic sell or gift. Get your titles, beneficiary designations, and spousal elections aligned so the healthy spouse keeps stability and the house isn't dragged into chaos. There are also protected transfers to a blind or disabled child and to certain trusts for their sole benefit. These are technical moves with strict drafting, but they're completely valid when the facts fit. If you have a disabled child, raise this early. Done right, the home can move without penalty and your child's benefits and housing can stay stable. Hardship waivers are the safety valve. States must have a way to waive recovery when it would cause undue hardship. The standards vary, but common examples include when the recovery would remove the sole income-producing asset for survivors, when the estate is of modest value per state threshold, or when the home is integral to a family business or farm. They're not guaranteed, and they don't wipe penalties from look-back gifts, but they can stop a post-death claim from forcing a sale that pushes survivors into public assistance. The move here is to collect proof early: business records, tax returns, property appraisals, and family income documentation. Before we continue, you need to understand documentation is the difference between winning and losing with exceptions. For Caregiver Child, keep a care log. Dates, tasks, hours, and notes about outcomes. Falls prevented, wound care, behavior redirection, appointments handled. Ask your doctor to write a short summary linking the care to delayed placement. Keep proof of residency, leases, driver's license, mail, and bills. For sibling equity, maintain title records, improvements with invoices, shared bill payment history, and a simple occupancy statement. For spousal protections, keep marriage records, updated deeds, and a current asset and income snapshot that aligns with your state's allowances. Let me give you a quick micro-sequence that works. A daughter moved in 3 years ago, cut her hours, and managed meds, meals transfers, and wound care. Mom's doctor notes 2 hospitalizations avoided and a year-long deferral of facility placement because of consistent home care. They kept a daily notebook, printed portal messages, and pharmacy logs. When placement became necessary, the attorney prepared a deed under the Caregiver Exception, attached a care affidavit, the doctor letter, and evidence of residency. No penalty. The house stayed with the daughter. Later, when Estate Recovery inquired, the transfer packet matched the rule and the case closed. Now the traps. Retroactive caregiver pay to a family member without a written market rate agreement looks like a disguised gift. Don't do it. Pay prospectively with a signed care contract and timesheets, or use the exception and transfer the home with proof. Second, last-minute title shuffles that try to invent sibling equity fail. Equity must pre-exist and be documented. Third, relying on oral promises or vague neighbor statements won't cut it. Agencies need objective evidence. There's one more edge case worth noting. Some states treat homes of modest value more gently in recovery or set small estate thresholds where they don't pursue claims. Others limit recovery to probate assets only. That's why you verify locally and tailor the plan. If your state is probate only for recovery and allows transfer on death deeds, that may combine well with spousal protections or a completed exception. If your state uses expanded recovery, you'll lean harder on irrevocable trusts and the clear exceptions. Action steps this month. If a child or sibling is already living with you, formalize the facts, update addresses, fix titles, and start logging care. Ask your doctor to include functional notes in visits. What keeps you safe at home? If you're the spouse at home, inventory assets and confirm you're titled cleanly, your rights are clear, and beneficiary designations won't detour into probate snarls. Build a proof folder with copies of everything: deeds, IDs, bills, logs, letters, and photos of home accessibility work done. Exceptions aren't magic. They're precise. When the facts fit and the paper tells the story, you keep the roof where it belongs. Next, we'll put the month-by-month shield in place so the 5-year clock runs while you live your life. The 2026 Shield. Start the 5-year clock now. If timing is guardrail 1 and tools are guardrail 2, this is the moment you put both to work. The goal is simple. Start the 5-year clock now, while you're healthy enough to choose calmly and build a month-by-month plan that doesn't yank equity back into danger. Who should start now? 3 signals. Age. If you're in your late 60s or older, the odds of needing some level of long-term care inside the next decade rise. Health. Any progressive diagnosis, memory changes, mobility limits, diabetes with complications, means timing matters. Family. If one adult child is the natural helper or already lives nearby, you can set roles and documents cleanly. If those boxes are even half checked, you're a candidate to start the Shield. Here's the month-by-month setup. Month 1 is consult and confirm. Book a meeting with an elder law attorney who practices in your state. Bring your deed, a simple asset list, beneficiary forms, and the Lookback ledger you started. Ask 2 questions. Can we use a Medicaid-focused, irrevocable trust for the house? And what exceptions apply to my facts if care comes sooner than expected? You're not committing, you're mapping. Month 2 is design. Your attorney drafts a Medicaid Asset Protection Trust with 3 anchors. You keep lifetime occupancy, you can't demand principal back, and you name an independent trustee with a clear successor. Ask for grantor tax treatment, so property tax and later step-up rules are preserved where allowed. Clarify how sale proceeds will be handled. Proceeds remain in trust. and confirm the trust is structured for your state's recovery definition. Month 3 is fund and record. You deed the home into the trust, the deed is recorded, and you update insurance to list the trust appropriately while keeping you as resident. Update your one-page house memo. The trust's name, trustee contact, insurer, taxes, homestead details, and where copies live. That record stops future confusion. Month 4 is confirm and align. Get a copy of the recorded deed, the final trust, and the insurance endorsement. Then align the rest of your plan. Update beneficiary designations on bank and investment accounts to payable on death or transfer on death where appropriate, but keep liquid funds in your name for living costs and spend down. Update powers of attorney and healthcare proxies so the same people can act. Month 5 is organize your quiet guardrails. Create a proof folder with the trust deed, insurance, tax bill, and your lookback ledger. Add a one-page instruction. Do not transfer assets out of the trust. Do not pay you trust principal. Call the attorney before any sale. Put a calendar reminder for an annual 30-minute tune-up, beneficiaries, tax bills, and any law changes. House strategy picks come next. Deed to trust is the core. You retain occupancy via a reserved right in the trust, not by keeping ownership. That protects your day-to-day life while shifting control. If sale is possible within 5 years, the trust can still sell, but the proceeds stay in the trust. If you plan to downsize, the trust can buy the next home. The practical rule: equity never comes back to you. It rides inside the trust. Quick fact check for Californians. Your look-back period is shorter, 30 months in many cases, but recovery rules still apply after death, so the trust and paper trail still matter. What about liquid assets? You need 2 lanes: what moves, what stays, and what you can safely spend down. Do not push cash into the trust unless your attorney directs it. Principal can't come back to you, and poor timing can trigger penalties. Keep living expenses and an emergency buffer in your name. Then build a clean spend-down plan for excess countable assets. Home safety upgrades, ramps, rails, walk-in shower, medical and dental care, paying off legitimate debt, prepaying an itemized funeral, and other allowable improvements. Every dollar needs a receipt in the proof pile. Alignment matters. Your will should reference the trust. Beneficiaries on POD/TOD accounts should point to people or the trust per your design, not to estate. Make sure your power of attorney authorizes trust-related actions your state allows, without giving the agent power to undo your shield. Small paperwork mismatches cause big, fixable headaches later. Now, you might be thinking, what if I need care before 5 years? You don't undo the shield. You build a bridge that can be private pay using liquid assets you kept out of the trust, targeted spend down to allowable items, documented caregiver agreements paid prospectively at market rates, and where appropriate, state programs that help at home. If a child qualifies for the caregiver exception, start logging care now with dates, tasks, and doctor notes tying care to delayed placement. If a sibling lives with you and contributes, clean up title and save proof. You want real options if the clock runs short. A quick, micro story. A couple in their early 70s set up the trust in month 3. They kept 6 months of expenses in checking, used savings to update bathrooms for safety, paid off a small loan, and prepaid an itemized funeral. 2 years later, he needed in-home care. They paid cleanly for a year, then applied for benefits with a tidy proof folder. The house stayed in trust, the 5-year clock kept running, and they never had to yank equity back. 2 common mistakes to avoid. First, adding yourself as trustee or giving yourself principal access. Control equals exposure. Pick an independent trustee. Second, funding late and then borrowing back from the trust. That breaks protection and creates a transfer problem. If you're inside 5 years, talk to counsel before any move. Last piece, put your plan in motion this month. 1 consult, 1 design, One deed, one folder. That's your 2026 shield, set quiet and working in the background while you live your life. The clean spend down, pay for care without breaking your shield. Now that your house sits safely in the Irrevocable Trust, the game is spending the right dollars in the right order without pulling equity back into danger or triggering penalties. Think of this as two lanes: allowable expenses that help you today, and clean records that prove every move later. Start with what counts as allowable spend. Home safety upgrades are perfect because they improve care and reduce future costs. Install grab bars, a walk-in shower, non-slip flooring, ramps, wider doorways, better lighting, handrails, lever handles, and a bedroom-level laundry. Replace trip-prone rugs, fix uneven thresholds, add a raised toilet and a sturdy shower seat, and make the primary bedroom accessible. These are not luxuries, they're medical risk reducers. Keep invoices, contractor licenses, photos before/after, and proof of payment in your proof folder. Medical care is another clean lane. Dental work you've deferred, hearing aids, glasses, foot care, durable medical equipment, and medications. If you need private caregivers, use written agreements at market rates, pay by check, get timesheets signed, and file 1099s or W-2S per your tax pros guidance. Therapies count, too: PT, OT, speech therapy, and home health under physician orders. Every receipt goes in the folder, labeled by date and category. Debt payoff is often smart. Paying off a legitimate mortgage, medical bills, or credit cards used for necessary expenses converts countable cash into reduced monthly outflow without creating gifts. Again, keep statements showing the balances before and the zeroed confirmation after. If you're paying a family loan, you need a signed promissory note created before the payment with reasonable interest and a schedule. Retroactive loans look like disguised gifts. Prepaying a funeral the right way is a classic move. Use an itemized, guaranteed, irrevocable pre-need contract with portability. Confirm what's guaranteed, what isn't, and where any excess funds go. Add the contract, receipts, and provider contact to your safeguard stack. That one step reduces family stress later and keeps cash from lingering as a countable asset. The protected budget model keeps you safe day to day. Set small, recurring payments for essentials, utilities, insurance, groceries, caregiving hours, and keep them consistent. Create a no-gift zone rule for the entire family. That means no birthday checks, no rent breaks without a written lease at fair market rent, and no casual help with someone else's bills. If you share costs with family under one roof, write a simple shared expense agreement and pay your portion by check or transfer. Treat every dollar as audit fuel. The proof pile is your friend. One folder with 5 tabs: home, medical, debt, funeral, caregiving. Inside each tab, put invoices, proof of payment, contracts, and a one-line note on why it was necessary. Add bank statements marked with highlighter to match the invoices. When the caseworker asks later, you hand them a story in order. Avoiding accidental gifts is a big deal. Common mistakes include cash tips to helpers without payroll records, reimbursing a grandchild for gas without receipts, buying furniture for a family member's room, or paying a child's phone plan. If it benefits someone else, skip it or formalize it with a written agreement and fair market pricing. For rent with family, sign a lease, set a market rate, collect receipts for utilities, and pay monthly by check. No handshake deals. Bridge funding options fill gaps without breaking your shield. Look at state programs that provide in-home help, adult daycare, respite, or limited home modifications. Some areas on aging have grants or sliding scale services. If you have long-term care insurance, coordinate benefits with your current needs, not aspirational ones. Consider small, targeted annuities only with counsel if you're in a medically needy or spousal planning lane. Design matters. Your attorney will tell you what's allowed locally. A quick micro story. A widow held too much cash after funding her trust. She used the next 3 months to add a walk-in shower, level floors, brighter lighting, and wider doors, then paid off 2 cards and completed dental work and new hearing aids. She set a caregiver agreement at 12 hours a week, paid by check with timesheets. Her folder had every receipt before / after photos and labeled statements. By the time she applied, the caseworker finished in 1 meeting. 2 traps to dodge. First, back paying a family caregiver without a prior written contract. That looks like a gift. If you need to compensate family, sign a care agreement now, set a market rate, keep timesheets, and pay going forward. Second, moving cash into the house trust or taking trust principal back. Don't. Equity must never flow back to you. Keep spend down in your own name and let the trust stay quiet. Finish with 2 quick wins. 1, book a single home safety visit. Rehab CAPS contractor or aging in place specialist to prioritize fixes, then knock them out with documented receipts. 2, open a fresh spend down checking account used only for allowable expenses. Every payment from that account becomes an easy to audit trail. Clean lanes, clean paper, shield intact. That's how you buy care without putting your home back on the table. The Safeguard Stack, paperwork that makes your kids' lives simple. The trust is built, the spend down lane is clean. Now, we make it usable. This is where good plans either shine or collapse. Your goal is simple. 1 folder, clear rolls, 0 scavenger hunts. Start with rolls. 3 hats, 3 people if possible. Your financial power of attorney handles money while you're alive, paying bills, talking to banks, coordinating with the attorney. Your healthcare proxy makes medical decisions if you can't, doctors, facilities, treatments. Your executor handles your estate after you pass, probate, final bills, and distributions. Some families use the same person for 2 roles, but clarity beats convenience. Write each name, phone, and email on 1 page so no one asks, who does what? Next, build a 1-page house memo. Title at the top, home and trust name. Then list trustee and successor trustee contacts, property address and parcel number, insurer and policy number, tax office account, utility providers, homestead or senior exemption notes, and where the recorded deed and trust live. Add 1 practical line. Before any sale or change, call attorney name, phone. That single page saves hours during a crisis. Now, the beneficiary check. Walk every account, checking, savings, CDs, investment, annuities, life insurance, and line up payable on death or transfer on death designations to match your plan. If the trust is supposed to receive proceeds, name the trust. If specific people are meant to receive items, name them. Avoid estate as beneficiary unless counsel says otherwise. It drags assets into probate and can invite recovery in expanded states. Print each confirmation screen or letter and drop it into the folder. Create your crisis folder, paper plus a mirrored digital copy. Paper lives in an easy-to-reach spot, not a locked safe nobody can open. Digital sits in a shared drive or password vault with emergency access enabled. Inside, place the trust and recorded deed, power of attorney and healthcare proxy, HIPAA release, living will or advance directive, the house memo, beneficiary confirmations, insurance cards, a current medication list, your driver's license and Medicare card copies, and the caregiver agreement if you have one. Add a cover page titled Call This First with your attorney, primary care, trustee, and financial POA in order. Now make it operable. Write a 1-page final wishes note for the first week if you pass. Simple, not poetic. Preferred funeral provider, service type, budget number, who has the folder, who to notify first. If you prepaid, attach the guaranteed contract. That tiny page stops family arguments and keeps spending within plan. Do a beneficiary/titles alignment pass. Titles on vehicles, co-ownership on small accounts, and safe deposit box access tend to lag. If a car will pass to a spouse or child, add transfer on death to the title where allowed. If a safe deposit box exists, add a co-renter or make sure your POA authorizes access. Put the box key in the folder and note the branch and box number. Install 2 quick guardrails. First, a no surprise accounts rule. Today, list every open account and credit line with the bank name, last 4 digits, and direct deposit sources. Second, a small float account for recurring bills, separate from spend down and trust matters, so autopay doesn't bounce if there's a hiccup. Set the annual 30-minute tune-up. Same month every year. Your checklist. Confirm trustees and agents are still willing and able. Verify beneficiaries and POD/TOD still match the plan. Reprint the house memo if anything changed. Take a photo of the property tax bill and insurance declarations page. Add any new medical directives or physician letters, and scan the folder to your shared drive. Put a reminder on your calendar and invite your trustee, so 2 people own the date. Name 2 backups, a successor financial POA and successor health proxy, plus a backup trustee. Capture their contact info in the folder. People move, get ill, or burn out. Backups prevent sudden gaps. Teach the system in 15 minutes. Call your 2 key people. Say, if something happens, the folder is in the hall cabinet. Digital copy is in the shared drive under safeguard. Call the attorney first, then the trustee. Utilities, taxes, and insurance are listed on the house memo. Do not move assets out of the trust or change beneficiaries without counsel. That short script turns chaos into a checklist. Avoid 4 expensive mistakes. 1. Storing the only originals in a bank box nobody can open on short notice. 2. Misaligned beneficiaries that override your will or trust. 3. Outdated addresses that stall claims and notices. For naming co-owners casually, co-ownership can expose assets to someone else's creditors and derail recovery planning. Finally, give your kids a fast start. Place 3 envelopes at the front of the folder, week 1, week 2, and week 4. Week 1 holds the final wishes note, funeral contract, house memo, and call this first sheet. Week 2 holds the trust, deed, POA, health proxy, and beneficiary confirmations. Week 4 holds the annual tune-up checklist and a blank log page for dates, names, and claim numbers. You've just turned a scary week into a sequence anyone can follow. The 7 expensive mistakes and the easy fixes. Mistake 1, we put the house in a living trust, so we're safe. You aren't. A revocable living trust is still you. Medicaid treats anything you control as yours for both eligibility and recovery. The fix, if you want real protection, use a Medicaid-focused, irrevocable trust with an independent trustee and no right to take principal back. Fund it early outside the lookback. Keep lifetime occupancy, but let equity live in the trust, not in your name. Mistake 2, we'll gift it later if needed. Late gifts light the penalty clock. Even helpful transfers inside the lookback create months of ineligibility. And the penalty often starts when you're otherwise eligible and apply, not when you gave the gift. The fix, start the 5-year clock now while you're healthy. If you're already inside the window, stop gifting, build a complete transfer ledger, pursue documented repayments where possible, and ask counsel about compliant notes or bridge strategies. Mistake 3, my kid moved in, so it's protected. Living together isn't the Caregiver Child Exception by itself. You need 2 years of co-residency immediately before institutionalization, plus proof the child's care delayed placement. The fix, paper the truth. Update the child's legal address, keep daily care logs, save messages with providers, and get a brief doctor letter tying the care to delayed admission. When the facts fit, record the transfer with a clean affidavit package. Mistake 4, small gifts don't count. That's an IRS myth. Medicaid doesn't use the annual gift exclusion. 10 $2,000 gifts are still $20,000 of uncompensated transfers under the microscope. The fix: adopt a no-gift zone today. If you must pay family, do it prospectively under a written, market-rate care agreement with timesheets and proper tax handling. Everything else waits until you've cleared strategy with your attorney. Mistake 5: I'll just pay cash to the facility. Paying is fine, paying sloppily isn't. Untracked cash outflow, back pay to relatives, and loose reimbursements look like gifts. The fix: run a clean spend-down lane. Pay by check from a dedicated account, keep invoices and timesheets, and file every receipt in a proof folder. Spend on allowable items, home safety upgrades, medical and dental care, real debt payoff, and an itemized irrevocable funeral. Then present it in order. Mistake 6: we'll figure it out after rehab. Discharge happens fast. Beds open and close in hours, and the wrong yes can trap you in a facility before paperwork is ready. The fix: plan before a discharge date appears. Meet an elder law attorney now. Set the trust and powers of attorney, build your lookback ledger and proof folder, and pre-wire your call this first list. When the hospital says we're next, you'll say home or this facility with your documents already aligned. Mistake 7: the state won't bother. Recovery is policy, not a mood. Claims come through probate, expanded recovery, or a quiet lien discovered at sale. The fix: assume enforcement and plan as if. Confirm whether your state is probate only or expanded. If probate only, align POD/TOD and trust tools with counsel. If expanded, lean on an irrevocable trust funded early and use exceptions you can. Prove. Either way, set hardship waiver proof aside now. Modest estate appraisals, income statements, or farm and business records, so the application isn't a scramble. Two cross-cutting traps magnify every mistake. First, control creep. If you name yourself trustee, keep a principal tap, or borrow back from the trust, you just turned protection into exposure. The fix: independent trustee, no backdoor access, written house rules in your folder that say do not distribute principal to me. Second, paperwork drift. Great plans die when beneficiaries, titles, and addresses don't match. The fix: annual 30-minute tune-up, beneficiaries confirmed, house memo updated, tax bill and insurance declarations rescanned, and agents reconfirmed. Let me give you 3 quick wins to lock this in. 1. Write a sticky note that says control equals exposure and put it on your folder. It'll stop you from helpful but harmful moves. 2. Create a no-gift family text today. Birthdays, tuition, gas money, all paused unless it's a written market rate agreement. 3. Add a 1-page transfer ledger to your folder and backfill 5 years of gifts, account closures, and big withdrawals. You'll prevent surprises and speed approvals later. Remember the pattern. Probate avoidance isn't recovery protection. Late gifts aren't strategy. They're penalties waiting to start. Co-residency isn't an exception without proof. Small gifts count. Sloppy cash looks like gifting. And we'll deal with it later becomes we wish we had started earlier. The easy fixes are boring on purpose. Real trust, early clock, clean spend down, tight paper, and simple rolls. Do those, and the house you work for stays where it belongs. If you already messed up, reset options. If you're watching this thinking, we already gifted, we already used a living trust. We're inside 5 years. Don't panic. You can't erase the clock, but you can tidy the record, reduce penalties, and keep the house plan on track. Start with the first reset. Start the clock anyway. If an irrevocable Medicaid-focused trust is right for you, set it up now. Earlier is still better than never. You won't get instant protection, but you stop making it worse. From today forward, no non-exempt gifts, no kitchen table deeds. No, we'll just try this. Install the real shield and let time work. Next, undo or document gifts. Pull a 5-year transfer ledger. Date, amount, recipient, purpose, proof. If a child can return funds, do it cleanly, repayment back to your account with a memo, not in cash. If repayment isn't possible, ask counsel whether a compliant promissory note fits your state's rules, actuarially sound, written, reasonable interest, periodic payments. Repayments reduce uncompensated transfers. Sloppy IOUs don't. If a family member was helping care without a written agreement, don't back pay. That looks like a gift. Instead, paper it prospectively. Sign a market rate caregiver contract. Set hours, keep timesheets, pay by check, and issue tax forms. For Caregiver Child Exception potential, start logging residency and care now. And ask your doctor for notes that tie today's care to delayed placement. You're building evidence, not stories. Now, fix titles and beneficiaries. If the house is still in your name and you're eligible for a real trust, fund it properly and record the deed. If a sibling has genuinely shared residency and equity, and the facts fit your exception, document ownership with recorded instruments. Don't invent equity after the fact. For accounts, align POD/TOD to match your plan, and avoid probate snarls that invite recovery in expanded states. Print confirmations and drop them into the folder. Build the proof binder, the thing that saves approvals and appeals. 5 tabs: transfers, care, home, debt, and contacts. Transfers, the ledger, bank statements, and any repayments or notes. Care, logs, timesheets, and physician letters. Home, deed, trust, insurance, taxes, and improvements with receipts and photos. Debt, statements showing balances and zeroed confirmations. Contacts, your attorney, trustee, POA, and facility billing. Label everything with dates. When a caseworker asks, you hand them a timeline, not a shoebox. Ask counsel fast. Time-sensitive corrections beat perfect ideas later. Bring 3 questions to the consult. Can any gifts be cured with repayment or notes? What's my penalty exposure under our state's divisor and start date rule? And what bridge funding keeps us covered until eligibility without touching trust principle? You want an exact sequence, not general advice. If a penalty is unavoidable, plan the bridge. Use clean spend down, home safety upgrades, legitimate medical, dental, and hearing work, and real debt payoff so you don't drain the wrong dollars. If a facility deposit or a few months of private pay are needed, map the exact amount and source. Consider whether a spouse's allowances, a compliant annuity in spousal cases, or state in-home supports can soften the gap. The goal is simple: cover the months the penalty creates without undoing your shield. What if the house already moved to a child? If it was inside 5 years and no exception fits, talk to counsel about returning the deed or partial interest to unwind the transfer. Don't guess. Sometimes restoring title cures the penalty. Other times it triggers more issues. If the child genuinely qualifies under caregiver or sibling rules, assemble the affidavit package now: residency evidence, care logs, equity proof, and the physician letter. 2 late-stage landmines to avoid. First, borrowing back from an irrevocable trust that blows the protection and looks like a sham. If you need liquidity, use your own accounts. Second, retroactive care, checks to family. Agencies see through it, and you've made the ledger worse. Pay prospectively with paperwork, or don't pay at all. Here's a clean 7-day reset plan. Day 1, freeze gifts. Write no gift zone on the folder. Day 2, build the 5-year transfer ledger. Day 3, book the elder law consult. Day 4, gather proofs, bank statements, deeds, bills, IDs, and care notes. Day 5, align beneficiaries and print confirmations. Day 6, draft a caregiver contract if care continues, and start timesheets. Day 7. Decide with counsel. Repay, note, cure, trust, bridge. Last point. Shame helps no one. The rules are dense. The timing is unforgiving. Resetting is about precision, not punishment. Start the clock, clean the paper, fix titles, and install the bridge. You'll feel control. Return the moment your folder stops being a mystery and becomes a map. Your care team. Who to call and when. You've got the plan. Now you need the people who make it painless. Think of this like building a small, specialized crew. Each pro owns one lane, delivers one clear result, and hands the baton cleanly to the next. Start with the elder law attorney. Their job is design, documents, and state-specific traps. You call them to draft the Medicaid-focused Irrevocable Trust, record the deed, align your powers of attorney and healthcare proxy, and map exceptions and hardship standards in your state. Ask them to confirm, in writing, 3 things: your state's recovery definition, probate only or expanded, the lookback divisor and penalty start rule, and exactly which exceptions fit your facts. A good attorney also scripts your bridge if care comes before 5 years. Clean spend-down items, caregiver agreements, documented repayments, and promissory notes that meet state rules. If timing tightens, they quarterback appeals, hardship waivers, and facility discussions. Next is the financial pro, ideally fee-only, coordinated with your attorney. Their job is cash flow map and friction control. They'll sequence which dollars pay for what, liquid assets for spend down, routine bills from a dedicated account, and how to avoid pulling trust principal. They calibrate your protected budget, set up automatic payments, and track receipts. They'll also flag Medicare and tax ripple effects, so you don't trip income thresholds while you fund care. If you use a funeral pre-need, they check contract terms and refund rules. If someone suggests products, they translate fees and suitability into plain English. No mystery money. Then bring in a care manager or experienced hospital social worker. Their value is real-world placement, programs, and timing. They know which facilities accept your coverage, which have reliable staffing, and which in-home services actually show up. They also help you capture the documentation that wins exceptions, functional notes from clinicians, caregiver logs that match symptoms and dates, and letters that tie care to delayed placement. Ask them for a short list, top 2 facilities, 1 backup, the area agency on aging contact, and any state waivers for in-home help, adult day, or home modifications. Keep those names and numbers in your crisis folder. Use the 2-call rule anytime stakes are high. 1 expert opinion can be biased by habit or incentives. A second independent call exposes blind spots before they're expensive. If an attorney says you don't qualify for an exception, ask another who files them regularly. If a facility claims a policy, ask the discharge planner and the admissions director to confirm in writing. If a product is pitched, have your fee-only planner sanity check it against your cash flow and timeline. Here's your simple meeting checklist, so every visit pays off. Bring your 1-page asset snapshot, the 5-year transfer ledger, the recorded deed, and trust. If done, power of attorney and healthcare proxy, the house memo, and your proof folder tabs, home, medical, debt, funeral, caregiving. Ask, what decisions should we lock now, what can wait, and what 1-page letter or script will help the next person say yes. Leave with a written plan, a task list with owners and dates, and the exact documents your next pro wants. Timing matters. Call the elder law attorney before a hospital discharge is on the calendar. Call the financial pro as soon as the trust is funded to set the spend down account and auto pays. Call the care manager when daily help reaches the this is hard every day moment, weeks, not hours before crisis. If a fall or diagnosis accelerates everything, put the attorney first, care manager second, financial pro third, all within 72 hours. 2 quick micro stories. A family waited until Friday afternoon to ask admissions about beds. They got a yes that evaporated Monday. The care manager would have told them. Confirmations in writing, ask for the business office contact, and request a 48-hour hold with a deposit receipt. Another family brought only a will to the elder law consult. Progress stalled. The fix was the 5-year ledger, IDs, deed, statements, and caregiver notes. One extra afternoon of prep saved 3 weeks of back and forth. Final guardrails. Appoint one coordinator, usually the financial POA, to schedule, track, and log. Send one-page summaries ahead of meetings so pros arrive ready. Keep every answer, quote, and policy in writing, dated, with a name and number. And when anyone says we don't do that, politely ask for the policy page. Paper wins arguments. Your crew executes the plan. Your folder makes it easy. Stress test. Will your plan survive a crisis? Plans look great on paper. Crises expose the weak seams. Let's run your plan through the hardest month of your life and make sure nothing snaps when time, money, and patience are all thin. Start with the fast lane most families miss: hospital to rehab to long-term care. In real life, it's a 72-hour blur. Admission, procedures, discharge planning, and we found a bed. Do you accept? If your trust is funded, powers of attorney are signed, and your proof folder is current, you can say yes or no based on your plan, not panic. If those pieces are missing, you're negotiating from the gurney. The discharge trap is simple. Saying yes before paperwork is ready. A facility can accept you, then ask for financials, 5-year statements, and authorizations. If your look-back ledger isn't ready, your POA doesn't match the bank's form, or your care logs aren't printable, admission stalls, and placement slips, the fix is to pre-stage. One folder, one digital mirror, one call this first list. Before any discharge meeting, your coordinator emails the facility a short packet: POA, health proxy, house memo, physician list, and the transfer ledger cover sheet. You look organized, so they move faster. Now run the out-of-state curveball. If you relocate near a child across state lines, you'll face new rules. Recovery definitions, penalty divisors, and trust interpretations can shift. Stress test portability with one question to counsel. If we move, what retitling or new deeds does this trust need? And in what order? Put that answer on your house memo. For the practical week 1 list, confirm homestead status, update insurance endorsements, and re-execute state-specific medical directives. Your shield survives the move because you mapped the paperwork before the truck arrived. Changes are the quiet risk. Titles, income, and spousal allowances change overnight. If the community spouse passes first, assets can flow the wrong way, bumping the institutionalized spouse over limits. Your stress test is to run a survivor cut sheet now. What shifts to whom, which beneficiary designations prevent accidental probate, and which accounts use POD/TOD to keep recovery out of reach in probate-only states. Add Social Security, survivor benefit timing, and pension elections to your one-page income map. When grief hits, you execute a checklist, not a guess. Let's do quick drills. First, the 10-minute phone rehearsal. Your coordinator calls your attorney's office and says, "We have a discharge Thursday. We have the trust, POA, look-back ledger, and care logs ready. If we need an exception affidavit or a promissory note, who signs and how fast can we file?" Get names, emails, and a same-day upload link. Second, the 3-document grab: POA, health proxy, and the call this first sheet. Can a backup put hands on those in under 2 minutes? If not, move the folder. Third, a backup contact tree. If the POA is traveling, who steps in? Write it on the cover. Now run the scenario that separates beginners from pros. Monday, abnormal labs CT ordered. Does CT need prior authorization? Who calls? If delayed, can the office schedule a peer-to-peer within 72 hours? Thursday, MRI, and biopsy ordered? Is the facility in network, and do anesthesia and pathology bill under covered groups? If pathology is out of network, what's the plan B? Next week, surgery booked in a hospital outpatient department with higher coinsurance. You ask for CPT codes and verify cost category because out-of-pocket spikes can derail private pay bridges. Post-op, skilled nursing recommended. Are 2 acceptable SNFs in network? And do they match your plan's authorization rhythm? If weekly recertifications cut days short, what documentation pushes extensions? Your scorecard is binary. Network confirmed by NPI? Yes. Authorizations requested with criteria in hand? Yes. Costs mapped by code category? Yes. Post-acute options pre-verified? Yes. 2 or more? No. Answers means tighten the plan or set a switch window. Travel reality check. If you split time across states, list the nearest in-network hospital and urgent care in both places, and store their NPIs. Add a line to your house memo. Urgent out-of-area coverage rules. Summary, plus the plan's escalation number. A daytime test call. Locks this down when you're calm, not coughing in a lobby. 2 more stress points. First, vendor churn. Home health agencies change staffing. Facilities change admissions criteria. Every 6 months, your coordinator calls the top 2 agencies and the preferred facility to confirm intake contacts and current requirements. Update the folder. Second, document drift. Each fall, re-sign any expiring forms, scan new insurance cards, and reprint the house memo. Put a sticky on the folder. Review date, next due date. Finish with a 24-hour crisis script your family can run. 1. Pull the folder. 2. Call the attorney and say, we're using the trust plan and spend down ledger. 3. Email the facility the POA packet and ledger cover. 4. Confirm discharge location in writing with the business office. 5. Start the care log again. Every task, every date, because today's notes win tomorrow's approvals. When stress hits, scripts save the plan. The 24-hour action plan. Let's lock this in with 5 moves you can finish by tomorrow. No theory, just steps that make the rest effortless. First, make 1 call. Book a 30 to 45-minute consult with a local elder law attorney who does Medicaid planning weekly, not occasionally. When you call, say this word for word. We're protecting a home with a Medicaid-focused, irrevocable trust and need state-specific guidance on lookback, recovery definition, and exceptions. We can bring our deed, a 5-year transfer ledger, and current statements. Ask for their earliest opening, in person or video. Put the appointment on the calendar and add 2 names for a backup firm if they're booked out. Momentum matters. Second, open a folder, paper plus digital. Title it Home Shield, your last name. Inside, start the proof pile. Copies of driver's licenses, Medicare cards, the deed, last property tax bill, homeowner's insurance declarations, and a 1-page list of accounts with the last 4 digits. Add a blank transfer ledger sheet and begin logging 5 years of gifts, large withdrawals, and account closures, date, amount, recipient, and purpose. Snap photos of any receipts you already have and drop them into a cloud folder with the same tab names. Home, medical, debt, funeral, caregiving. This prevents the approval delay that kills good plans. Third, write the 1-page house memo. Put the property address, parcel number, insurer, policy number, tax office account, utility providers, and the attorney's contact. Add your 2 key instructions at the bottom. Before any sale or title change, call attorney name, and trust principal is not to be distributed to me. Print 2 copies. 1 goes at the front of the folder, 1 on your fridge. Email a PDF to your financial power of attorney and your trustee, or your likely trustee if you're pre-trust. Fourth, calendar 2 dates. set a 30-minute annual tune-up on the same month every year to confirm beneficiaries, reprint the house memo, and scan the latest insurance and tax pages. Then add a 60-day follow-up from today to confirm 3 things are done. The attorney consult the recorded deed if you move forward with the trust and the spend-down account setup. Calendar nudges keep plans from drifting. 5th, tell 2 people where the folder lives and who to call first. Keep it simple. If something happens, the folder is in the hall cabinet labeled Home Shield. The digital copy is in our shared drive. Call attorney first, then trustee/POA. Do not move assets or change titles without counsel. That 30 seconds replaces hours of confusion in a crisis. Now, 3 microboosters if you've got another 30 minutes. Open a dedicated spend-down checking account to pay only allowable expenses, home safety, medical, debt, and pre-need funeral. Auto-pay utilities and insurance from it, so the audit trail is clean. Start a care log if family is helping dates, tasks, hours, and outcomes. Ask your primary care provider for a short note that documents functional needs and how current help keeps you safe at home. Those 2 pages can unlock the Caregiver Child Exception later. What if you hit resistance tomorrow? If the first attorney can't see you for weeks, call 2 more. If your bank fumbles POD/TOD forms, ask for the branch manager and request printed confirmations the same day. If family pushes for gifts, point to the folder and say, "No gift zone" until counsel approves in writing. Your job isn't arguing, it's installing guardrails. Here's the 24-hour checklist you can read aloud as you go. 1. Schedule the attorney. 2. Build the folder with ID, deed, insurance, tax, and the transfer ledger. 3. Write and print the house memo. 4. Set the annual tune-up and the 60-day follow-up. 5. Brief 2 people and share the digital link. 6. Optional, open the spend-down account, start the care log, and get the doctor note. By this time tomorrow, you'll have a living plan, not a pile of intentions. You'll know exactly who to call, where the papers sit, how the dollars flow, and what not to touch. That's the difference between hoping for protection and owning it. Start now, keep it boring, and let the 5-year clock run in the background while you live your life. Quick wins from viewers like you. Let me give you 5 fast stories from people who used this exact playbook and got results without drama. Story 1. Daughter caregiver exception saved the house. Maria's mom resisted placement for years. When mobility slid, Maria moved in. She changed her driver's license, added herself to utilities, kept a daily care log, and messaged the doctor after falls and med changes. 2 years later, a hospitalization forced long-term care. Their elder law attorney packaged the transfer, a deed to Maria under the Caregiver Child Exception, a physician letter tying Maria's care to delayed placement, and proof of continuous residency. No penalty when Estate Recovery sent a form letter after mom passed. The same packet closed the file. The difference wasn't luck. It was a clean timeline, credible logs, and a doctor note that used dates, not adjectives. Story 2. Late start Irrevocable Trust. Clock started, stress dropped. James and Lila, early 70s, thought their living trust protected them. 1 consult later, they learned control equals exposure. Month 1, they signed a Medicaid-focused irrevocable trust, named their niece as trustee, and reserved lifetime occupancy. Month 2, they recorded the deed, added the trust to insurance, and built a proof folder. They kept a 6-month cash buffer outside the trust and spent down on a walk-in shower, dental work, and hearing aids. Were they inside 5 years? Yes. Did they wait anyway? No. They stopped making it worse. 2 years in, he needed home care. They paid cleanly, and the clock kept running. Lila says the biggest relief was knowing they'd never pull equity back. Story 3. Spend down with receipts, faster approval. Ellen had too much cash and no plan. She opened a dedicated spend-down checking account and used it only for allowable items. Week 1, ramps, grab bars, lighting, and a raised toilet. Week 2, dental implants and new glasses. Week 3, a caregiver agreement at market rate with timesheets. Every invoice, receipt, and bank line went into 5 tabs: home, medical, debt, funeral, caregiving. When she applied, her caseworker literally said, "Thank you for making this easy." Approval arrived in weeks, not months. The key wasn't the size of the spend. It was the audit trail that told a simple, necessary story. Story 4, title and beneficiary fix, probate detour avoided. Raj and Asha lived in a probate-only recovery state. Their attorney confirmed the rule, then moved the house into an irrevocable trust and aligned every account, pod/TOD to people or the trust, never estate. They added transfer on death to the car, updated life insurance beneficiaries, and wrote a 1-page house memo. When Asha died first, nothing wandered into probate. Later, when Raj passed, the trust distributed per plan, the car passed by TOD, and the small accounts cleared with pod confirmations. No probate detour, no recovery hook through the estate. It looked invisible from the outside because the paperwork matched the goal. Story 5, annual tune-up caught an insurance lapse. Denise did the 30-minute yearly review. She verified beneficiaries, reprinted the house memo, scanned the tax bill and insurance declarations, and checked the trust endorsement on her homeowner's policy. It was missing after a carrier change. One email fixed it before a claim ever tested it. She also updated her successor trustee after a cousin moved away. Tiny tweaks, huge protection. She calls it boring on purpose, which is exactly the point. Common threads you can copy today. They acted before discharge panic, they wrote things down, and they kept control low. The trust had an independent trustee. The spend down used a dedicated account. The care logs were daily, not reconstructed later. And every family set a no-gift zone, which stopped cute mistakes from becoming penalties. 2 micro wins I see constantly. First, the physician letter upgrade. Ask your doctor for a brief note that says, because of X, Y, Z limitations, continuous caregiver support delayed institutional placement by approximately N months. That sentence is gold for caregiver child cases. Second, the call this first cover sheet in your folder. Names, numbers, and order. Attorney, trustee/POA, primary care, preferred facility. In a crisis, your helper reads it like a recipe. If you've already started, drop one quick update in the comments, what you fixed and how fast it felt better. If you're just beginning, pick one win, schedule the consult, build the proof folder, or start the care log. Small, boring, done this week beats perfect. Someday, you'll feel it the moment your plan moves from ideas to paper. Lightning Q&A, fast clarifications seniors ask. Does a living trust protect my house from Medicaid? No. A revocable living trust is still you. Medicaid treats assets you control as countable for eligibility and recoverable after death. If you want real protection, you need a properly drafted Medicaid-focused, irrevocable trust funded outside the Lookback, with no right to pull principal back and an independent trustee. Can I still live in my house if it's in an irrevocable trust? Yes, if the trust is drafted to reserve your lifetime occupancy. You keep the right to live there, pay taxes and insurance, and maintain homestead or senior exemptions where allowed. The trust, not you, owns the equity. If the home is sold, proceeds must remain in the trust. What if I move states? Plans are portable, but paperwork isn't automatic. Laws differ on recovery scope, look-back divisors, and deed forms. Before moving, ask counsel whether your trust needs a new situs clause, a fresh deed, homestead refiling, and updated medical directives. Do the retitle sequence in order so you don't pull equity back to your name. And remember, California is different. Shorter look back, about 30 months, different forms and active rule changes. So get local advice before boxes are packed. Do small gifts really count? Yes. Medicaid ignores the IRS annual gift exclusion. 10 $500 gifts are still $5,000 of uncompensated transfers in the look back, which can create a penalty. Adopt a no-gift zone. If you must pay family for help, do it prospectively with a written, market-rate caregiver agreement, timesheets, and proper tax handling. What if I need care before 5 years? Don't unwind the trust. Build a bridge. Clean spend down on allowable items, home safety, medical, dental, hearing, documented caregiver agreements, short periods of private pay, and locally available in-home supports. If a caregiver child or sibling exception might fit, start logging residency and care now, and get a brief doctor letter tying care to delayed placement. Can Medicaid kick my spouse out? No. The community spouse can remain in the home, which is exempt while they live there. Spousal resource and income allowances protect a portion of assets and income, so they aren't impoverished. For 2025, the max seats RA in many states is about $157,920. Check your state. After the spouse passes, recovery rules return. So align titles, beneficiaries, and trust design now to avoid avoidable exposure. Does a transfer on death deed stop estate recovery? It can help in probate-only states by keeping the house out of probate, but it doesn't beat expanded recovery or fix look-back penalties. Verify your state's recovery definition. Often, a TOD deed pairs with an irrevocable trust or a proven exception, not as a standalone fix. Are hardship waivers real? Yes, but they're narrow and evidence-driven. Common grounds include sole income-producing property like a working farm, modest estate thresholds, or survivors who would need public assistance if recovery proceeds. They don't erase look-back penalties for gifts. Build proof early. Tax returns, appraisals, business records, and family income. If my sibling lives with me, can I transfer the house? Only if they had an equity interest before your facility admission and lived there at least 1 year immediately before. Record co-ownership now if it reflects reality, keep proof of contributions, and be ready to show continuous residency. Last-minute title shuffles fail. What happens if we already used a living trust? You're not sunk. Keep it for probate avoidance, but install the Medicaid-focused, irrevocable trust for the house now. And start the clock. Stop gifting, build the 5-year transfer ledger, cure what you can, and set a bridge with counsel. Here's the takeaway. Start the 5-year clock with a real irrevocable trust, keep airtight records, and use documented exceptions. Control down, proof up. If this saved you time or stress, subscribe and watch the deep dives on clean spend downs and trust setup next. Share this with the family planner tonight so everyone knows the path and nobody guesses in a crisis.